to list a few. So the Fourth Geneva Convention, the Convention Against Torture, the Rome Statute of the International Criminal Court, Permanent Court of International Justice, the International Law Commission, the Fourth Hague Convention, the International Convention on Civil and Political Rights, were just a few. And what I think this ties into is the fact that some of the kind of severity and extent of some of the violations. So you get these paragraphs that just kind of list the violations, and they're quite extraordinary when they're put like that. Like this one, it's just the mission finds that in a number of cases Israel failed to take visible precautions required by customary law reflecting Article 57.2a of Additional Protocol 1 to avoid and minimise loss of civilian life.
Well, what page are you on right now?
Sorry?
What page are you on right now?
It's on page 413. The firing of white phosphorus shells over the UNRWA compound in Gaza City is one of such cases in which precautions were not taken in the choice of weapons and in the attack. The intentional strike at Al-Quds Hospital using high-explosive artillery shells and white phosphorus also violated Articles 18 and 19 of the Fourth Geneva Convention, and it goes on. So, for me, that was the significance of that, the kind of sheer extent of these violations. There seemed to be quite a clear conceptual argument that Goldstone was constructing in this last bit, and what it seemed to be was that so there are these very severe violations, which are also deliberate, as we've heard from other people, alongside that, victims have a right to a remedy or reparation, and part of remedy or reparation is the guarantee of non-repetition, or could be. So, to quote here, we have reparation can take the form of restitution, compensation or satisfaction, but may also include measures of rehabilitation of victims and guarantees of non-repetition. So this is a right for victims, and also an obligation on state parties to various treaties. And then what he seemed to argue from then is that basically the national legal systems in place in both Israel and the occupied territories are basically inadequate or deliberately obstructive or contributing to the injustice. So he, especially with respect to Israel, there are various mechanisms that mean that Palestinians basically can't have recourse to the legal system there. For example, reading here, there are limitations on when a claim has to be made, so that it has to be done within 2 months of the damage. That's a quite minor one. But then this seems to me the most extraordinary, that the courts basically can't see claims from subjects of enemy states, to quote, or members of terrorist organisations. And because Gaza is effectively declared, well, actually, I don't know, I shouldn't say that. But yeah, subjects of enemy states that they can't hear cases from. And another one of these mechanisms is that they can't hear cases from areas that are declared conflict zones. This last law was recently, or it was overturned by the Supreme Court in 2006, but the others still stand. And another one of these mechanisms is that the damage which is seen as the result of acts of war also can't are kind of invalid in the eyes of the law. So an example of this was that in a case in 2002, during the mission Operation Defense of Shield in Nablus, a guy, well, this came to court, a guy who was on his roof, he's proven to be a civilian, was shot by a helicopter, and this was not a valid case because it was an act of war, and it, to quote, the Jerusalem Magistrates Court held that an airstrike is clearly an act of war that the legislator intended to make immune to prosecution. Quoting the magistrate there. So that was pretty interesting. Following on from that, the fact that Palestinians don't really have recourse to the Israeli legal system. He basically argues for the necessity of kind of international legal intervention, if you want to call it that. And from that flows the concept of universal jurisdiction, which is enshrined in various laws. But of course this raises, although it's not controversial, that states are party to these things, it does raise problems because, in how it kind of can conflict with national legal systems, and that what you do when someone is not a signatory to one of these laws. For example, customary international law, which is recognised, for example, in the Geneva Conventions, it applies to non-signatories, but something like the Rome Statute of the International Criminal Court does not, and both Israel and the US voted against it in 1998 when it was just starting up, and have subsequently unsigned themselves in 2002. I know other states voted against it, including China and Iraq. But on the other hand, there are some cases which are ongoing where people have kind of taken the legal route in this conflict, and one of them is this is happening in Spain. Just read this out. In connection with past events in the occupied Palestinian territory, the mission is aware of one case pending before the Spanish courts. It concerns the killing of Masli Salah Shahadeh on 22nd of July 2002 by a one-ton bomb fired by the Israeli F-16. The strike also killed a number of other people in the same house and in the house next door. The investigating judge admitted the case for investigation on the basis of the universality principle, and after determining that Israeli internal investigation system did not satisfy the requirements of the right to an effective remedy. And there are other cases in the Netherlands, Norway and South Africa that are also pending. And I'll just, well, the last thing is about recommendations. But the recommendations address everything that's come up in the report so far, but I think one paragraph that might be worth reading out, just a short one, is this one, which kind of shows, I guess, the ultimate reach of this kind of pursuit of international law. And it's the mission recommends that upon receipt of the committee's report, the Security Council should consider the situation, and in the absence of good faith investigations that are independent and in conformity with international standards, for having been undertaken within 6 months of the date of this resolution. Again, acting under Chapter 7 of the Charter of the UN, should refer the situation in Gaza to the prosecutor of the International Criminal Court, pursuant to Article 13b of the Rome Statute. So that invokes Chapter 7, which if anyone knows is just about the Security Council's right to determine threats to international peace and its right to then take action, be it military or non-military. And then it also mentions here the International Criminal Court. So it's kind of taking it to those levels. And I'll leave it there.